I have no doubt that that night, Troy 100% wanted to kill me. There's no doubt. It was really scary. It was like there was a demon in his eyes, or he was dead or in his eyes, I don't know, is what could have happened that night. And if he would have succeeded, what would have happened to my children, because they were in the home. There's no way he would have left them as witnesses.
All right, this is State of Ohio versus Troy Adams, case 25CR43029. Mr. Adams is present with his counsel, Ted Brittingham. The state is represented by Brian Goodyear. We're here for sentencing. Mr. Goodyear, is there a statement from the victim?
Yes, Your Honor, she is present. She would like to speak to the court.
All right.
Name Inju Lisa Berry. I'm not sure how I want to start, but maybe just a little bit of context. I have no doubt that that night, Troy 100% wanted to kill me. There's no doubt. It was really scary. It was like there was a demon in his eyes, or he was dead or in his eyes, I don't know. But what I think about is what could have happened that night, and if he would have succeeded, what would have happened to my children, because they were in the home. There's no way he would have left them as witnesses. And luckily, by the grace of God and the swift response from the Mason police, it didn't escalate further. And this is not the first time. This might have happened here in Warren County, but it is not the first time. It's happened in Indiana, and it's always the same MO. He always takes my phone and breaks it, so I can't call for help. And then he'll physically restrain me and attack me, and it's slowly getting worse, and obviously this time it was with a gun. And then afterwards, I always get blamed for his actions, and then I am a fool, and I fall for the manipulation and the love bombing, and I take him back, and that's my responsibility. But, I hate that he's using being a veteran as an excuse, because it's not, right? I'm a veteran, and because of my training, that's what kept me alive that night. And if it was anybody else, I can't say that would have been the same. So I feel like it's not an excuse. And he's received, I've never met anybody who's received more therapy and more treatment. Anger management, PTSD counseling. He's gone through a stint where he had to report a couple times a day with a breathalyzer, not quite sure what that's called. Used tons of VA resources. He's had tons of tests, neurological examinations. He's been through pain therapy. He's been through trauma groups, men's groups. And what he did was a choice. He made that choice. And he's done everything possible up until this point to avoid accountability. And that's what scares me, because in his mind, still somehow it's somebody else's fault, and he's not taking responsibility for his actions. It's left lasting effects on me and my kids. Not that I am complaining about this, but my daughter still sleeps with me every night, and I have to check in with her every day because she's always worried about where I am. And that was never the case before. He never apologizes. And even last time we were in court, he violated the no contact order. I'm sitting there, and he's standing in front of me and professing his love. And he's not supposed to talk to me. And so that's what scares me. And the longer he's in prison, the longer I feel safe. And I think that's it.
All right. I'm sorry, go ahead.
I'm not sure what else to say, but that's, I think that's it.
All right, thank you.
Judge, in addition, there's a few things I wanted to point out, and I think that the victim touched on this a little bit, talking about the amount of treatment the defendant's already received in his lifetime. And you read the PSI, and what does he say in the PSI? He says, "Wow, I don't know that guy that did that. That was Drinking Troy that did that. That's not me." Well, the problem is, Drinking Troy's been doing this for years, and he's never changed his behavior. In let's see here. I believe he received an OVI he was convicted of OVI in 2008 in California, convicted of OVI in 2015 in Indiana. He's had other charges that have been either we don't know the disposition to or they've been dismissed. And then, in addition, Your Honor, in 2018, as was alluded to by the victim, he was charged with felony domestic battery, felony strangulation, interference with the reporting of a crime, and resisting law enforcement in Delaware Circuit Court in Indiana, which is the exact same charges we have here. He went through Veterans Court there and received all the treatment you heard the victim tell you about. And then here we are, where he does the exact same thing again. And I don't think that someone who has so clearly been engaged in criminal activity related to alcohol use in the past should be able to come into court and say, you know what, don't punish me as much because that was when I was drunk, and that really isn't me. I don't think that's a viable excuse. In addition, Judge, I will tell you, I listened for a long time to Mr. Adams' jail calls and his home wave calls with his daughter and other people, and he has consistently maintained that it's not his fault that he was drinking. He claimed over and over and over again that the victim gave him drinks in cans that look like flavored water that he drinks, and somehow he had no idea he was drinking alcohol, and all of a sudden he blacks out and doesn't know what happened. So he has been blaming the victim the entire time. Now he won't say that to you and he won't say that in the PSI, but that's what he said consistently for quite a while. And he's shaking his head to me yes right now, so apparently he still believes that. Judge, I think that this is extremely troubling behavior. He held the victim at gunpoint. He strangled her to where she couldn't breathe, which is exactly what the strangling part he's done before. And I think this is just a series of escalations that ultimately will lead to him causing serious injury or killing someone he's in a relationship with. I think it's pretty clear that he's not going to stop this behavior. That being the case, the state would ask the court to impose a very substantial prison sentence. In this case, Judge, he's facing, he was convicted of abduction with a 3-year firearm specification, and strangulation with a 3-year firearm specification, and obstructing official business are 3 felonies, and then misdemeanor domestic violence. Because these felonies are not the type that would require the application of 2914B1G, the 2 firearm specifications would merge. So really, he only faces the imposition of 1 3-year firearm specification. The minimum sentence he faces is 3.5 years. So 6 months on one of the felonies and then 3 years on the firearm specification. But I don't think 3.5 years, Judge, in these circumstances is nearly sufficient. I would also argue that the abduction and strangulation are 2 separate offenses. They're not allied. They are committed with separate animus, considering the nature of the offenses and what the offenses encompass. Abduction is restraining someone's liberty, in circumstances which cause them fear or create a risk of physical harm. And strangulation is the act of actually placing his hands on her neck and restricting her ability to breathe. So I think those are 2 non-allied offenses. The state would ask the court to impose a prison sentence consecutive on those 2 charges. So the maximum on those 2 charges would be 50, there would be 4.5 years, so 7.5 years would be the maximum sentence possible on those 2 charges, and that's what the state thinks is an appropriate sentence in this case. Thank you.
All right, thank you.
At this stage, the court must decide whether the offenses merge for sentencing, how the firearm specification applies, and whether consecutive prison terms are justified under Ohio law. The analysis turns on whether the conduct involved separate animus, whether community control would adequately punish the offenses, and whether a prison term is necessary to protect the public. The sentencing range now before the court reflects both the statutory minimums and the discretion permitted when aggravating factors are present.
Mr. Brittingham, anything on behalf of Mr. Adams?
Yes, Your Honor. Thank you. in his past, Troy worked for a long time as a night manager at Walmart, store manager. Disabilities ultimately made that job impossible because he was struck by lightning for the second time. That's not in dispute. I believe that was confirmed at a prior hearing, actually, before the court. He served in the U.S. Army. I think this was in the PSI, but I do want to highlight a couple things. Served in the U.S. Army from 82 to 85, also in the reserves from 86 to 90. Received an honorable discharge from the U.S. Army. He did undergo a significant trauma there, not war-related trauma, and I would prefer not to air it here in open court, but
I think I recall.
most recently, in the prior to this, he was beginning in the early stages of counseling therapy for that incident. He had not dealt with that emotional issue prior to this most recent time with the VA. Prior to, I believe, 2018, Troy had not been, or I'm sorry, prior to 2018, Troy had a significant drinking problem. He hadn't drank since 2018 until this event in September of last year. He had been with Miss Berry in her life, in her kids' lives since 2013. And I think I used the past tense when I said that Troy had a significant drinking problem. I'd like to revise that a little bit and say Troy has a drinking problem, because that doesn't go away. He has a drinking problem. When he is drinking, he's found himself in court many times. What the court has not heard from Mr. Goodyear or from Ms. Berry was that Troy acts in any way close to this when he's not drinking. The criminal record would indicate, as well as everything the court has heard, when he's drinking, he's a bad guy. When he's not drinking, he's not a bad guy. And I also don't think it's in dispute, Your Honor, that on this particular day, Mr. Adams did not purchase or obtain these. He was drinking. He didn't purchase or obtain those for himself. I don't think that's in dispute either. But I've had many meetings with Troy in this case while this has been pending. In those meetings, he's reflected on those events of September 15th. He reflects on those events when he's not with me. He's still shocked and mortified that he behaved in that way. He loved Miss Berry. He still does. He loves her kids. I mean, he hurt her. And he's going to have to live with that day to day, regardless of what the court does. Just a brief mention of the 2018 case that was dismissed out of Indiana. He did Veterans Court on that case. It was dismissed. If somebody has a presumption of innocence while a case is pending, then certainly they should have a presumption of innocence when that case is dismissed. So I understand the state brings that up, and obviously the court would want to know about something like that, but long and short, that case was dismissed. I would also point out from the PSI that Troy's had no rule violations while he's been incarcerated. I do know that the staff there at the jail was very interested in about something that was going on in the jail, and Troy helped them with that. I'm sure the court can come to the conclusion of what I'm talking about there. And Troy has also provided me with a certificate of a program that he did complete while he was in the jail. If the court wants to see that, I'm happy to present it, but it was the 5 life skill classes at the Warren County Jail. Completed that earlier this month. So I point out all those things, Your Honor, to say that I think there are plenty of mitigating circumstances here that would not warrant the maximum sentence, and actually would warrant much closer, if not the minimum sentence in this particular case. And Your Honor, I know Troy has prepared a statement as well, but as far as what I wanted to say, I would submit.
Okay, thank you. Mr. Adams, anything you want to say, sir?
Yes, sir. First thing I want to do is I want to give this to Inju. There's a $23,800 cash for a basement and a $25,000 loan for the basement at 5848 Running Fox Lane in Mason, Ohio. And a $3,500 payment that she made back to me. And then I paid $45,300 myself. I don't want her to pay me the $45,000 that she owes me. I'm just going to go ahead and take care of it myself. And I put paid in full and I signed it. So she doesn't have to worry about that anymore. And she can just forget about paying me back on that. Because it was never about money for me and her. It was just about, I wanted to be her husband and be a family and not just be together. I wanted to complete the family. But she never would. It was just hard. As I think about the day that we're reading off my charges, I was mortified because I don't remember anything. The last thing I remember is trying to get to you and Alexia on the 18th hole. I saw you two walking on the 18th hole where they were giving stuff away in the pizza thing. I was getting dizzy and I thought I was getting ready to have a seizure like I did at Dad's funeral. And before I could get to you, everything went black, and that's the last thing I remember. The next thing I remember is waking up in the front of the house and I felt like my back was broke. I was completely ashamed of myself, and I am still at a loss for words. It was like I was listening to someone else's charges. I was beside myself. I would never intentionally harm you or the children or anyone for that matter. I have known and felt brutality at the hands of others and would never and would not wish that on anyone. I'm extremely ashamed of myself, yet my actions brought us here today. It is hard for me to grasp that I hurt and scared you and you. I truly don't remember what happened, and that scares me. That was not me that night. It was the evil inside. I couldn't control of me from all the trauma that I have suffered over the years. I have issues from being attacked, tied up, and sexually assaulted in the military that I recently told you about, and started to have flashbacks that past week that we talked about. So starting right now, Andrew, I'm asking you to find it in your heart to forgive me. You've never forgiven anybody for anything, and you're walking around with so much hate inside of you. I wish you would learn to forgive people, just even for the smallest things. Carrying around all that hate inside of you is killing you. I'm truly sorry you had to endure what you did. I wish we could talk because, you know, it's important how important your feelings and desires are to me. But if this is all the closure we get, I pray you don't burn with hate towards me. I'm so sorry. I love you more than I've ever loved anybody in my life. You know that you're my soulmate. I have these for you and the kids. These are poems that I have written. I haven't wrote a poem since I first went in the military. But God promised that He would heal my brain. I've talked to Him through a prophet. I've turned my life over to Jesus as my Savior, and He started to heal my brain, and I'm doing a lot better. I'm so sorry. I just miss you and the kids. I feel like I'm dying every day.
I think that's all. Your Honor.
Okay, thank you. I've considered the statements that have been made here today. Pre-sentence investigation report. I've considered the purposes and principles of sentencing set forth in the revised code, which are to protect the public from future crime by the offender and others, and to punish using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. The court finds the defendant is not amenable to community control, and a prison is necessary to fulfill the purposes and principles of sentencing, including punishment, deterrence, and protection of the public. Probation would not adequately punish the defendant and would seriously demean what happened in this case. Therefore, the sentence is 18 months on count 1, the felony 3, 3 years on the firearm specification. On count 2, the strangulation is 18 months to run concurrent. There's a merger of the firearm specification. The domestic violence, 6 months. The obstructing official business, 12 months. Both of those are to run concurrent for a total of 54 months. This carries post-release control, which is supervision by the adult parole authority. It's mandatory for a period of up to 3 years, but not less than 1 year. If you violate the rules of post-release control, the adult parole authority could send you back to prison for 9 months per violation, up to a total of 27 months additional. If you are convicted of a new felony during that period of supervision, the court that has the new felony case can revoke post-release control, impose whatever time remains on supervision. If you have less than a year remaining on supervision, they can add a year to the sentence in the new felony case. Other than appellate rights, is there any, there's no fines or cost. Is there anything else, Mr. Goodyear?
No, Your Honor.
Any jail credit is
It's 129.
129 days. Mr. Brittingham, is there anything I've not addressed?
I don't believe so, Your Honor.
All right. Mr. Adams, you have a right to appeal this sentence. You have 30 days from today to file a notice of appeal. If you cannot afford an attorney will be appointed to represent you. Any document you need to be provided at no cost. Do you have any questions, sir? All right, that's all.
The court's disposition rested on the statutory framework governing felony sentencing and firearm specifications. In determining the appropriate sentence, the court applied Ohio Revised Code Section 2929.11 and Section 2929.12, weighing the purposes of felony sentencing, including punishment, deterrence, and protection of the public, against the seriousness of the conduct and the defendant's criminal history. The court found the defendant not amenable to community control and concluded that a prison term was necessary to satisfy the statutory objectives. In addressing the firearm specification, the court applied Ohio Revised Code, Section 2941.145, determining that only one mandatory firearm specification could be imposed as permitted by law. Regarding consecutive sentencing, the court made the findings required under Ohio Revised Code, Section 2929.14, subsection C, subsection 4, concluding that consecutive terms were necessary to protect the public and that a concurrent sentence would fail to reflect the seriousness of the conduct. The court also determined that the offenses involved separate animus, allowing the charges to be sentenced independently rather than merged. The sentence imposed included a term of incarceration, followed by mandatory post-release control under Ohio Revised Code, Section 2967.28, with the court advising that violations of supervision could result in additional confinement. This disposition reflects the court's application of Ohio's structured sentencing scheme within the limits set by statute.